is 12:30. We're going to get started. Thank you all for coming. I'm Scott Starbird. I am responsible for the public affairs function at Databricks. And part of that role is to help monitor and influence regulation to the extent we can. And as part of that role, Databricks is a member of the Software Alliance, also called BSA. BSA originally stood for Business Software Alliance. And Matteo Quattrocchi is a director of policy for EMEA based in Brussels. And he has done us a great favor of flying all the way out here to present on the EU AI Act. There's AI regulation brewing in many parts of the world, as many of you know. But the EU AI Act is the one that's kind of the farthest along in many respects. It's probably of the various comprehensive AI regulations that are on course, the one that will be in effect the earliest, or at least tied with some. But it's very comprehensive, and there's been a lot of work done on the language and how various aspects are treated. And it's going to set a precedent, we believe, for other AI regulation everywhere. So understanding what's going on with that, I think, is very valuable. And with that, I will turn it over to Matteo.
I think I might not. Thank you so much, Scott, and thank you so much for having me here. It's okay. Happy to be here over from Brussels. It's great to see so many of you here. The idea is not to have a frontal presentation and very boring EU law, so questions are welcome. So it's going to be a lot of buzzwords, and Brussels is one of those bubbles where people use a lot of buzzwords in policy, comprehensive legislative framework, and first of its kind, and stuff like that. So the EU AI Act has been a long time coming. I've joined BSA 5 years ago, and essentially I started working on AI policy ever since I joined. The EU's approach to regulation is almost always one of precautionary aspects. The idea is let's find all the risks and challenges associated with a specific technology or sector, and how can we address that. The European Commission, which is the body that puts together legislative proposal, caught early on the fact that AI is fundamentally a horizontal technology, so obviously it can be put to use in a number of sectors vertically that probably are uncountable at this stage. So the idea that the European Commission had when in 2021 put together the proposal and released it was to have sort of a pyramid, and I know that pyramids are not necessarily always the most welcome things to see. It is not a scheme, although it is sometimes very mystifying. The idea of the AI Act is to establish a risk-based approach to artificial intelligence. That means regulating specific use cases in specific sectors that pose specific risks and create compliance obligations that are tailored to those risks. So it's a lot of words. But the way that it works in practice is fundamentally this pyramid, and that was the original proposal. What you would have is use cases of AI that are not considered to pose specific risks, are not even mentioned in the AI Act, are out of scope. They will continue to be under EU law in general, and I think that's an important point to make. It's true in the EU, it's true in the US, it's true everywhere in the world. AI does not work in a vacuum. A lot of you are probably working in compliance or are lawyers. Obviously, there are rules that apply to AI even without a comprehensive framework on AI. So those minimal risk AI will still be under those rules, be that on privacy or cybersecurity and many other rules. Then there are some systems that are considered to have limited specific risks. These are, for example, artificial intelligence systems that can help in creating deepfakes or chatbots. In those cases, the AI Act would seek to just have transparency requirements. You essentially have to communicate you're interacting with an AI, or you have to do your best to make sure that it's understood that a particular content has been generated with AI. The most important part of the pyramid is the third one, is high risk. This is where the bulk of the AI Act obligations would be. Essentially, there is an annex that would describe a number of sectors. Some of them are commercial, such as employment, critical infrastructure. Some of them are in the public domain, public services, such as education, law enforcement, administration of justice. So as you can imagine, companies tend to go more towards those services that are more commercial. Chiefly employment and critical infrastructure. In such cases, there are descriptions of what use cases of AI would be in the scope of the EU AI Act, and at the tip of the pyramid is unacceptable risk. There is a number of forbidden uses under the AI, so the unacceptable risk is our AI systems that are not allowed in the EU. Many of them are probably already legal anyway. The AI Act essentially makes it even clearer. Here's a couple of examples of those uses of AI. Some of them are right straight out of Black Mirror. Some of them are more perception of what AI might do rather than what actually happens. Some of them are much more tangible, predictive policing. One key aspect of AI that is extremely controversial right now in Europe is biometric identification in public spaces, AI that is used to identify through mostly facial recognition or other biometric features in public spaces. The European Parliament, the main political body of the European Union, is vehemently trying to have a very broad description of that, while member states and law enforcement, especially, as you can imagine, are trying to have some exceptions and the ability to use biometric identification in public spaces for a number of possible crimes. As I mentioned, there are other examples of high risk. These are uses that are permitted in EU, but would trigger a number of compliance obligations. For example, in critical infrastructure, as I mentioned, materially influencing decision on employment, migration and border control, access to public services, education, and so forth. The way that the AI Act works is fairly complicated, as with everything in the European Union. So the good news is that so far, many, including BSA, have advocated for a self-conformity assessment. So what would happen is that when the AI Act enters into force, a company that is developing an AI system that they deem be in the scope of the AI Act would just go look at the list, assess whether or not they feel they are in the scope, and then go through all the compliance obligation and self-assess whether or not they have respected those, and then register in the AI system and the EU database. And once that happens, that is a self-declaration of conformity. The AI can receive the CE marking. The CE marking is done for products in the EU, is everything that is allowed to be marketed in the EU. And then the system can be placed on the market. This obviously bears liability. So your system is now registered in the EU, which means that the various market supervisory authorities now have the power to come and check if you actually did comply with the AI Act. The AI Act also seeks to create a sort of a binary relationship within the value chain of AI. They seek to essentially give obligations to other developers or deployers. And one of the main criticisms BSA has had and other stakeholders is how binary this approach is. It's fundamentally you're a developer or deployer. There isn't a lot of scope there to recognize how diverse the value chain of AI can be. And we will talk about foundation models in a second, where it's even more diverse and more complex. A lot of obligations would go on developers. So a lot of the stuff that happens before an AI system is put on the market is fundamentally the bulk of the compliance obligations. This range from very sensible and probably things that most companies do in their own way, obligations such as data governance, making sure that your system is not biased, and showing that you have a bias management system in your development of AI. Cybersecurity, accuracy, robustness of systems. The key part is essentially taking those processes that most companies already have and make them compliant with the AI Act, almost to a language question, not related to a technical level, because fundamentally we believe most of those requirements to be relatively reasonable. The difference is what happens with foundation models. So when the AI Act was put out in 2021, nobody really knew anything about foundation models, generative AI, ChatGPT. So the way it works in the European Union is that the European Commission, which is the executive body, will put out a proposal, and then the member states and the European Parliament will separately debate possible changes to that proposal, and once they both are done, they will negotiate and come to a final version. It's very similar to what happens in Congress between the House and the Senate. The only difference is that in the European Union, the European Commission is the only entity that is allowed to propose new legislation. So when that happened in 2021, nobody had any idea about foundation models. So through the process of, especially the European Parliament, ChatGPT became the huge success that is today. And that obviously attracted a lot of attention, especially at the political level, to see what could be done at the legislative level for foundation models. As I mentioned, often enough what happens is that, especially with new technologies, policymakers will seize on the uses that are more prominent of a specific technology and will tend to assimilate those users with the broader spectrum of that particular technology, which is to say, often enough you will see that some of the proposals that are coming out of the European Union seem to be tailored toward the more famous generative AI and foundation models, ChatGPT and others, rather than the much broader and diverse ecosystem that is foundation models and generative AI. The good news is that there is a lot of reasonable people in the European Parliament and the European institutions. It's just very complicated to bridge the needs at the political level to make sure that the citizens understand why a piece of legislation regulates or not certain uses of technology, and at the same time try and understand the technicalities of something that is evolving very fast. So what the European Parliament suggested was actually to have specific rules in place just for foundation models. As I mentioned, the AI Act is a risk-based framework, which means that all those obligations that I mentioned before are tailored to the specific risk understanding of the use case of AI. So if you can take an example and we think about employment, if you take an AI that is materially influencing decisions on employment, the compliance obligations you will have, for example, on data governance are going to be specific to that risk categorization. If you take something in critical infrastructure, that's going to be radically different. The risk management and understanding what it is you have to comply with is going to be radically different from employment. A very simple example is bias. Obviously, you're going to have very, very heavy bias requirements when it comes to employment. You will probably not have as heavy requirements when it comes to bias for unfair bias in the context of protected categories in the context of critical infrastructure. So that's how the AI Act works. While this is something that we think is a good way to approach it, foundation models are problematic in this space because they can be applied to a number of uses. Sometimes the number is something that we can't even imagine. So it's quite hard for the AI Act to adjust to something that doesn't necessarily have an intended purpose, rather can be applied in a number of uses, therefore might not have a specific risk categorization that can give you the guidance to get compliance obligations in place. What the European Parliament tried to do, as I mentioned, is to have a specific track of obligations for foundation models. Many of those, again, we believe are sensible, are tailored especially to make sure that along the value chain there is a flow of information that is needed for compliance. So sharing technical documentation, making sure that there is a degree of understanding of the data sets that are being used, so that as the foundation model is further improved or applied in specific settings, those entities that make those decisions have the necessary information for further compliance in the European Union. At the same time, the sort of knee-jerk reaction to how prominent ChatGPT became also brought in a number of compliance obligations that we feel are unwarranted, and a lot of other stakeholders, and not just us, are complaining about this. For example, having a number of downstream requirements and controls over time. This is particularly problematic in the space of open source, as you can imagine. The AI Act does not necessarily distinguish between open source and non-open source or free-to-use foundation models. So as you can imagine, you might be required as an open source developer or even as an open source deployer that further integrates the model in their systems to have a degree of control downstream that you're legally not able to have. So that's something that we're trying to push back against and trying to bring in some ideas and how you can address that, bring a degree of flexibility also on the ability of control that developers have. And I'm sure we'll also hear more from Databricks and how that can be helped at the development and design phase to make sure that customers of open source and in general foundation models can feel safe in knowing that they're complying with EU law. One last part that is probably the most important part of all of this is the timing of it all. So one important factor to include in this is that next year, at the beginning of June, the European Parliament will go through elections, which means that the term of the current Parliament will end. Therefore, all files will have to be voted in the European Parliament plenary before that happens. Because the EU is a very complicated yet beautifully diverse place, there are more than 20 languages official languages in the EU, and every legislative act has to be fully translated in all those languages before it can be voted, which means that we expect a cutoff date for negotiations to be finalized on the AI Act to be between December of this year and January of next year to give enough time to lawyer linguists to go to the text, make it coherent, and translate it in all the European Union languages before it can be voted by the European Parliament. That essentially puts a timing of 6 months, basically from today, for the European institutions to come to an agreement on the AI Act. So it's going to be a lot of work, and there are a lot of things pending. As I mentioned, one of the most controversial aspects is biometric identification. As you can imagine, there is a strong tension between law enforcement and civil rights on what kind of AI can be used in public spaces for biometric identification purposes. Certain governments are trying to have specific crimes that might warrant the use of this AI. Others would just want to have the possibility to use it whenever it's needed for national security or law enforcement reasons. On the other hand, you will have a number of civil rights organizations that are obviously very concerned about the use of these systems that are more pervasive and scale up much faster compared to what is currently being in use. For the part where BSA is going to be heavily involved, as I mentioned, foundation models, this is something that is really new. We have seen a proposal from the European Parliament that we don't love but don't hate either. There is a lot of work to be done there, and we expect that to be one of the biggest focus on during the negotiations between the various EU institutions. So we're really hoping to be part of that, to bring in some sensible technical aspects as to why certain things make sense this or that way. As I mentioned, as BSA, we believe that it's not unreasonable to have a degree of obligation for foundation models, especially because they can be powerful. They can have a number of uses that are not even thought about as they're in development. A number of these obligations we feel make sense, having good data governance practices, having a good amount of technical documentation that can be shared along the AI value chain. At the same time, we also want to make sure that the diversity of the value chain is seen and respected by the Act. And again, that eventually boils down to what we call allocation of responsibilities and trying to find the best entities along the value chain that are placed to comply with the AI Act as those systems go on the market. So as I mentioned, the timeline is there. You see that strange number, which is 2026. The AI Act right now has a 2 years period for entry into force, which means that from the moment it's going to be voted, it's going to be law of the land, but it will give companies 2 years to become compliant with the AI Act. So since we expect 2 to 3 years, since we expect a vote in 2024, the earliest would be probably around May or April 2026 at the AI Act to become law. Maybe one last point, and then I think it's best we open it for questions, is, as Scott very rightfully mentioned, this is going to be the first of its kind in a comprehensive regulatory framework for artificial intelligence. Therefore, the EU has a bit the advantage of being a first mover in this space. And many of you may be familiar with the GDPR, the comprehensive privacy regulation that the EU put together in 2016. We don't necessarily expect to see that kind of monumental impact in that space as GDPR had, because there are already a lot of countries that are moving towards having AI regulation, as opposed to GDPR being really the first of its kind for many years. At the same time, the EU being a huge market will essentially force a number of companies that are probably a lot of them are present here to comply with many of their products already with the EU. So in a way, almost automatically, they will have most of their products comply. A large number of politicians remain very concerned that the AI Act may be a bit too burdensome, and what the end result might be is that a lot of AI is developed outside the EU, and then it's brought compliant to the EU only when it's completely finished, and that obviously is also another tension you will have between the various political aspects of the European institution, the concerns you have there to encourage AI, but at the same time have very strong risk-averse, in a way, legislative framework. So that is more or less the lay of the land of the AI Act. I'm happy to talk more, but I think it's probably best if there are any questions to get some questions from the crowd.
So I'll pass on the microphone around. Once you're done with question, please pass it back to me.
We're going to open it up for questions for Matteo in just a minute. I just wanted to take a moment to mention briefly that Databricks has a lot of tools on its platform that are available that can help with the compliance. Much of the compliance requirements are going to be pre-launch in terms of documentation, putting in place a risk management system, and then also monitoring afterwards and quality control systems, et cetera. And Unity Catalog is particularly important, I think, because of the governance tools, security and data lineage, and on MLflow and Lakehouse AI, which was talked about this morning. There are tools that will help with testing, monitoring, recalibration, and we have a lot of other things in the works that we're going to be announcing very, very shortly. Also, some of our partners have tools that can be very helpful. The tools are out there. We'll be working to package them together so that they'll be more identifiable and easy to use, and especially as the regulatory requirements become clearer over time. With that, I'd love to open it up for questions for Matteo.
Is there one in front here? And then
Hey there. In terms of liability, is that the kind of thing that's determined, once it's voted on, or at what point do you start to understand the intended, cost for non-compliance to an organization?
pretty early on. So the AI Act mimics GDPR, and I mean, it's not confirmed yet, but we would expect somewhere between 3 to 4% of global revenue as the highest possible level of fines for non-compliance with the AI Act. I have to say that even in the world of GDPR, where there was first of its kind in having these kind of fines, we have never seen those being levied until very recently for very large companies. So I see it sometimes, some reporting when it comes to GDPR, fines can vary from 100 euros, which is roughly $100, to 1-point-something billion euros for Google and other companies that obviously are much larger. So the structure would be that similar. The question of governance is much more complex, though, as compared to GDPR. GDPR is essentially just for personal data, so it's the grounds for processing for personal data. The AI Act is horizontal, which means that while every member state will have to designate one authority that can coordinate the enforcement and governance of the AI Act at the national level, there's going to be a lot of verticals there for specific authorities that already exist for years. Imagine in the US, you would have EEOC being part of that when it comes to employment. You will have similar labor organizations in the European Union at the member state level that will have to coordinate with the national supervisory authority on top of the data protection authorities. So it's a bit hard right now to establish how these fines are going to be levied if they happen, but the fundamental structure will be similar to that of GDPR. The additional layer of complication is that there is also a proposal on AI liability and a revision of product liability framework in the EU. So those are also not done, but they might add a degree of liability that right now is not strict liability, so we're happy to see that in case of non-compliance with the AI Act. So a system that is non-compliant with the AI Act that has caused harm might be also considered liable under civil liability rules, but we will have to see as that is developed. It's a bit counterintuitive, but as with every government, the European Commission has a lot of competing departments. So the proposal came out from the department in charge of digital affairs, and then the department in charge of justice also put together the liability proposal, and they came out together. Our main criticism was, if you haven't agreed on the AI Act, how can you have a liability that is tied to that? So we're hopeful to see that that's not done before the AI Act, but there's going to be 2 tiers, more or less, of liability possibly when it comes to AI in the European Union.
Oh, I didn't realize how loud I was. One of the questions that I had was whether or not the EU AI Act will cover stuff like triangulation, or is that whether or not that's covered within GDPR? Because I think the concern with personal data and removing PII is that even when you have that, if you have a particular rare disease where it's somebody of a certain age with within a certain country, if you could potentially figure out who that person is and what that person might be doing. And so I'm wondering whether or not the EU AI Act is going to cover that, or whether or not there's any particular impacts.
So in general, GDPR and other privacy rules will remain prominent compared to the AI Act. So the AI Act will always be under the umbrella of the specific processing for personal data. GDPR itself actually has a number of provisions that apply directly to AI, for example, for automated decision-making when it regards to personal data. One aspect that is not specific to triangulation, but it overlaps with personal data is bias management. So the AI Act includes one specific ground for processing when it comes to bias management, so the ability to process specific protected categories of data that would require consent under GDPR without consent when it's done for the purposes of mitigating unfair bias. So that can happen, but it's done under very, very specific circumstances, and it has to be done only specifically for the purposes of mitigating unfair bias. So it wouldn't be done to mitigate pseudonymization or anonymization. The additional layer of complication is the fact that the European Union does not have competence on national security. So the AI Act cannot apply fully to national security activities. A member state should remain in exclusive national competence. So in those cases in which that is pertinent to law enforcement and national security, the AI Act might not be the place where you would look for those kind of rules. So one in the front, right there.
Hi. One of the big announcements from Databricks this morning was actually a marketplace for models. Could you maybe speak a little bit about what the AI Act would say, especially if maybe you're setting your own model on this marketplace that's arguably putting it kind of quote onto the market if it's accessible in the EU. Some of them may not reach the levels of foundational models. It could actually be quite small and tailored. Could you maybe speak a little bit about kind of how the AI Act might impact that?
Of course. So there are essentially two tiers in the AI Act. You're either high risk, or you're, at least in the current proposals, we'll have to see how that ends up, and that's always the it depends lawyerish answer that you have to have before you get in trouble. And the other one is foundation models. So if the particular AI system is neither high risk or foundation model, is it fundamentally not going to be in the scope of the AI Act, which again doesn't mean that there's no rules. It means that either EU law or US law or wherever the system is developed will apply, but the specific compliance obligations of the AI Act will not be triggered unless that tool has some transparency requirements, again, for deepfakes or for chatbots. If it's instead a foundation model, that's where it gets very tricky. So again, as it's put on the market, you're going to have a number of compliance obligations. We'll have to see how those shape up. We're hopeful to see those to be only data governance, a degree of technical documentation, and some information obligations to share those along the value chain. What's very tricky to understand is that the AI Act borrows a concept for the medical devices legislation, which is called substantial modifications. So every time a system receives a substantial modification, which is something that is akin to a very big software update, something that changes the tool enough to make it different from before, that triggers, again, compliance with the AI Act. So if your model, let's say that it is a foundation model, is taken by someone else and receives a degree of modifications that, for example, make it more specific to a sector, that would trigger, again, all the compliance obligation for foundation models. And that's where we see important flow of information between customers so that you as the original developer share the information that that entity will need to comply. One key aspect that we've been pushing very strongly on is the fact that when it comes to high risk, because these obligations are tailored around risk, it's very important that the entity that decides the destination is the one that has to comply with the AI Act, because the developer might not have awareness that that's happening, might not have the necessary knowledge for that. And we can make a very simple example of a very simple AI tool that is done, let's say, for image recognition. So not even a foundation model, it can be used for a number of things, it can recognize shapes. As that is developed and it's put into healthcare or in employment to recognize CVs and fundamentally alter the possible course of employment, the original developer will not have the necessary knowledge of the risk of the specific deployment. So we feel that the deployer that takes on that responsibility should have the responsibility of the AI Act. At the same time, we also feel, and I think it's just good policy for developers, that there should be some obligation to sharing information so that that entity is able to comply with the AI Act down the line. So it's going to be complex and interlocking, and we'll see if we have a cottage industry of AI compliance lawyers as we did for privacy. It's probably going to be the case.
Thank you for the mic. I almost felt like a singer. But our similarity reside in our shared humanity that can be expressed into different form of emotion. So based on your expertise and experience as a policy director, is there anything about implementing Gen AI in the UA in a UE or workplace that worries you, make you lose your sleep, but at the same time also give you the hope because you see the potential benefits?
I'll start with the hope. Yes, I mean it's incredible because as BSA as a number of members, it's incredible to see how many crazy, amazing uses of AI that we never thought about are going to come to fruition in the future, already happening, things that I would have never thought about. I think it's always easy to go towards healthcare. I mean, one great example, we were talking about it with Scott some days ago, is Databricks being able to actually take old code that is often redundant or even impossible to understand for new machines, and through generative AI make it now integrated in machines and new code and translated into new languages that are currently in use. That's very nice and very cool, and imagine the possibilities there. A lot of work is happening on digital twins. For example, one member of BSA, Autodesk, is helping reconstructing the Notre Dame Cathedral after the fire. So thanks to that, they are creating a full digital twin of the cathedral and rebuilding it as faithfully as possible. And these are things that are just simply amazing. There are other things that give you pause. I'm proud to say that no BSA member so far has brought things to the fore that are particularly concerning, but definitely there are concerns of AI having very severe impact on the economy, and I mean, you probably have seen a lot of letters about the risk of singularity or extinction. I have to say, it's easy to dismiss that with a slay of hand. It's so important also to hear those concerns, but at the same time, the AI Act is not truly about that, and it would be also reductive to expect that one piece of legislation is able to stop the Terminator. Otherwise, Sarah Connor would not have really had 4 or 5 movies to do that. They could have just gone to Congress. But it's obviously important to make sure that there are necessary technical obligations to enforce and protect those rights that already exist. And that's where I feel that AI Act can be helpful. So, you know, there are risks, obviously, and we shouldn't be dismissive about them. I don't know where the mic
Here.
Here, sorry.
Down here, yeah. So my name is Nick Vidal. I'm here representing the Open Source Initiative. I see that in the AI Act, you mentioned open source AI, particularly free and open source AI, a few times. I think it's like 8 or 9 times. But nowhere in the draft do you actually define what's actually free and open source AI. So the website, together with several other organizations, we're making an open invitation for developers, lawyers, to try to create this definition to help the AI Act and other legislation around the world as well. So I shared some cards with everyone in the audience to make this invitation. It's an open process. And I just wanted to thank you for the opportunity.
That's great. And yeah,
thank you.
It's important to find stuff. So
exactly.
Yeah.
Thanks.
Quick question on people who are working in the future on LLMs or something. For example, let's say, for instance, like OpenAI has worked on these for a very long time, and then they're very successful, and then they've got a product. And for someone who's new to come to at that mature stage will be very difficult and close to impossible, right? So there'll be very key players, and then they'll be dominant. And then they'll be deciding what everybody or the rest of the world has to listen, and then what they have to be educated about. Is there something limiting, because there have to be multiple players as well in the game? Then it'll be a fair game. So is there something towards that perspective?
That's the most complicated part right now. So trying to get a sense of how you integrate those entities and get a sense of where obligations might lie and end up. The biggest challenge that policymakers feel, and that's the reason why often they might have proposals that seem a bit excessive, is that they want to be able to have what they call future-proof legislation. And their fear is that by the time they put together a proposal, that's not going to be relevant anymore because technology in the meantime has changed. I think a key aspect that we keep on hammering on is the fact that the AI Act is creating technical obligations. There are concerns that are specific to rights that already exist. What's important is to create a framework that makes it understood who has to do what to protect those rights that exist without having to be too worried about specifying those rights and stuff like that because they already exist, and that makes the compliance obligations a bit too much. We talked about GDPR. It's very, very complicated to disentangle your obligations when it comes to GDPR and when it comes to the AI Act. For example, one thing that worries us when it comes to foundation models is that if you impose downstream obligations on the original developer, if that foundation model originally is meant to be, let's say, a simple, so to speak, LLM and generative AI, and then it's put into a specific use case, let's say in healthcare, it's going to be processing personal data. That has specific repercussions when it comes to GDPR because the entity that is deciding the destination of the data is called the controller, and the entity that processes the data on their behalf is the processor. If you have to have downstream obligations, you might be forced to become a controller, even if you don't have the ability to do it, you don't want to do it, and contractually you have no desire to do that. So it's also very complicated to explain that, to make sure that these legislations don't overlap, while at the same time making sure that the rules give the degree of protection that is needed. And again, we see the AI Act as kind of like a layer that goes on top of what already exists. So you look at what the gaps are in the protection of specific rights and create technical obligations that might help there. And it is an iterative process. There are review clauses, so there's going to be the possibility for this to be updated. There can be guidance that makes it more specific, so it's not going to be that once it's done, it's over and nobody will talk about it. We fully expect this to be a very long process, so that's going to be definitely the case.
Hi, so you already mentioned just now that the GDPR and the AI Act kind of pose different levels of requirements, and obviously even outside of Europe, while they're not in the same stage of being enforced, there's new frameworks for risks in AI in the US and in different states, and they may pose different types of requirements, like the AI Act mentions bias in a very general way, while some more niche regulations talk about bias in very specific ways. So I guess, what's your perspective on how in practice companies are going to have to address these potentially conflicting definitions of explainability, bias, or just different reporting requirements while trying to deploy products across markets? And yeah.
I wish I had a really simple answer for you to say, don't worry, it's going to be fine. It's going to be a very, very painful process of enforcement and compliance. Our hope is that the supervisory authorities are supportive of companies trying to comply with the AI Act, because we still feel that most of these processes are already in place for most trustworthy, sensible companies. The question is, how do you showcase that you're doing it across the board according to the law? One good news is that the AI Act also provides for sandboxes. So that's still up for discussion, but one item that we find will be quite important is the ability for companies to go on a voluntary basis to these sandboxes and test their AI and be guided towards compliance and see what it is that they really are required to do, so that they get some support from supervisory authorities at the national level. But there is definitely a risk of fragmentation because different countries might have a different interpretation of specific concepts. It may be explainability, it may be discrimination, it may be bias. And yeah, I'm not going to lie and say it's not going to be painful, because it's going to be, but we're hopeful.
Fair.
Was there a trigger for the AI Act in EU, or how did AI become a priority for EU?
I'll use a diplomatic answer. So one joke that a lot of people make in Brussels, and I think I make it here because I don't think there's anybody from the European Commission, is that often the European Commission has an amazing set of solutions, and all they need is the problem for that, so they're going to look around for it, and they'll do that. To be fair, AI was not the case. So as I mentioned, I joined BSA 5 years ago, and even then, what the European Commission did, it put together a high-level expert group of experts of artificial intelligence, from academics to practitioners to companies to trade associations, and put together a set of ethical principles on how to develop AI, and a set of possible policy recommendations on how to approach possible regulation to AI. That was a very long process. We were happy to be involved, and our suggestion has always been, if you want to have a legislative framework for AI, it should be risk-based, and you should be specific about what kind of AI is going to be in scope of this possible framework. So it was a very lengthy process. We feel is meritorious. As BSA, we're also working with Congress to see if there's a possibility for a similar framework also in the US. It would be beneficial from two perspectives. On one hand, you have something that can be integrated with the AI Act, so you would have the US and the EU being the global leaders in setting rules on AI, and at the same time, it would also make sure that the US doesn't fall behind as it has on privacy when it comes to legislation, to make sure that it remains a leader on its own when it comes to policy. But when it comes to the AI Act, I'm much more lenient towards the European Union in terms of being very eager to have legislation. It's warranted to have something. I think we're at time.
Yeah, that's
Maybe
the end of the session, so thank you all.
But I'll be happy to stay outside if anybody has more questions. So thank you very much.